Empire's legacy of military discipline is notable for its extreme punishments such as dissemination, where 1 in 10 soldiers were executed for collective disobedience. Collective disobedience included such offenses as mutiny, and mutiny included offenses like tree-sitting, sabotage, among others. Tree-sitting meant that the rank and file of men in the mutiny would choose to sit under a tree and not do any work. Specialized disciplinary tribunals with restrictive functions to handle disciplinary matters that are peculiar to and connected with the discipline and regulation of the armed forces. The Constituent Assembly, while debating the setup of the army courts back in 1992, envisaged military courts as special purpose vehicles to enforce discipline within the military and ensure that there was a battle-ready and disciplined force anytime they were needed. Leading up to the enactment of the 1995 Constitution, the CA did not support granting army jurisdiction over civilians. The Constituent Assembly laid emphasis on the necessity to guarantee a free and fair trial and other due process rights and critical need for the independence of the courts-martial, stressing that their role be limited to handling military-specific offenses against military personnel. The General Court-Martial, as currently set up under the UPDF Act, is fundamentally incompatible with the constitutional safeguards for a fair hearing and is unconstitutional, and therefore its exercise of judicial power is equally unconstitutional. To re-echo the words in Curry, the court-martial system structure, including the convening authority's power to prefer charges and select court-martial members and report back to superiors, is fundamentally at odds with the due process and constitutional in the civilian justice system and even unjustified in the military justice system. Having found as above, I hereby make the following declarations. Judicial power in Uganda is exercised by the courts of judicature and such subordinate courts as Parliament may by law establish. The court-martial system established under Section 197 of the UPDF Act is therefore one such subordinate court. I would declare that Section 197 of the UPDF Act, which establishes the General Court-Martial, is not in breach of the Constitution. However, it is an overreach when the UPDF Act creates an offense that targets persons not otherwise subject to military law, making them criminally liable before the court-martials for offenses of aiding and abetting. For creating such vulnerability, I would declare Section 117, which it is now, and Section 1171H, 1177 of the UPDA Act unconstitutional. I would set aside the decision of the Constitutional Court in this regard. I find Sections 1, Section 177, and Sections 1171G of the UPDA Act in its current form unconstitutional for enabling the surreptitious prosecution of civilians in military courts. For clarity, the above sections provide that every person found in unlawful possession of arms, ammunition, equipment ordinarily being the monopoly of the defense forces or to other classified stores as prescribed is liable to be prosecuted before a court-martial. I uphold the decision of the Constitutional Court to the effect that the General Court-Martial is a constitutionally established court set up to handle cases of military discipline for UPDF members, but lacks jurisdiction to try civilians for offenses under the Penal Code or other enactments. I would declare that the arrest, detention, prosecution before the court-martial of the cross-appellant stroke respondent and civilians of equivalence under section 1191G, read 1171G, is in breach of Articles 21, 28, and 44 of the Constitution of the Republic of Uganda. For reasons above, I would make the following orders. In their current form, courts-martial are not in a position to deliver a free and fair trial as guaranteed under Article 28(1) and 44 of the Constitution of the Republic of Uganda. I would forthwith suspend all operations of courts-martial save for the hearing of disciplinary matters pertaining to serving officers. All convictions and sentences passed by courts-martial would be suspended. A pathway would be put in place to ensure that all citizens hitherto convicted and sentenced by the military courts-martial have their convictions and sentences subjected to judicial review before a civilian court of competent jurisdiction to determine whether the convict received a fair hearing and impartial prosecution. This order would not apply to persons who were convicted and sentenced by courts-martial and have already served their sentences. For efficiency and proportionality purposes, I would invoke the doctrine of prospective annulment on decisions, orders, and sentences of courts-martial which have already been served. That notwithstanding, I would order that all cases currently pending trial before the courts-martial be suspended forthwith. An injunction don't issue restraining the instigation, reopening, or continuance of the respondent's trial before the general court-martial or other courts-martial. I join issue with the recommendations or advisory orders proposed by the Honorable the Chief Justice. To these, I would humbly wish to propose a status of the offender determination in civilian courts. When the necessary legislative amendments have occurred, it should be imperative that prior to subjecting a civilian or person considered so by color of right before future courts-martial, a status of offender determination be made to the High Court of Uganda. Such investigation should be subject to the highest scrutiny, akin to extradition proceedings or movement of jurisdiction. The courts would have to be satisfied by an explicit demonstration that the interests of justice cannot be served in the ordinary course of judicature. This standard would be applied to all matters in review. I further would propose to refer the proposals for amendments raised in Second Lieutenant of 1 Ambrose versus Uganda, Supreme Court Criminal Appeal number 48 of 2021. The Supreme Court found that the UPDF Act in its current form creates a separate judicial system which has no recourse for appeal or judicial review to superior courts. The court called for legal reform and
You will please bear with her. I think she's got a little cold,
Lord Chief Justice. The elements of the right to a fair hearing, as highlighted in Article 28(1) of the Ugandan Constitution, are similarly expressed in various international covenants, the pertinent one for present purposes being the International Covenant on Civil and Political Rights. The United Nations Human Rights Committee has since pronounced itself on Article 14 of the ICCPR in its General Comment number 13 of 1984 and General Comment number 32 of 2007. General Comment number 13 proposes that the trial of civilians in military courts should ensue in very exceptional circumstances and in conditions that genuinely abide the dictates of Article 14 of the ICCPR. It was in January 2006 supplemented with the draft principles governing the administration of justice through military tribunals. The draft principles on military tribunals were rooted in the 1984 General Comment number 13 and must now be construed with due regard for the committee's revised position as encapsulated in the 2007 General Comment number 32. General Comment number 32 demonstrates that the Human Rights Committee does recognize the trial of civilians in military courts, albeit in exceptional circumstances and within established parameters. It calls upon state parties to guarantee the fairness, impartiality, and independence of such trials, which in any event would only be justified in exceptional circumstances and for serious and objective reasons, with appropriate regard for the suitability of civilian courts for the individuals and offences in question. That is the universally established command of Article 14 of the ICCPR. Courts-martial are established by the UPDF Act by dint of Article 210 of the Constitution to preside over the service offences defined in Section 1 of the UPDF Act, which include the offences enshrined in Part 6 of that Act. The intricate nature of the service offences they preside over supports the view that the primary function of courts-martial is indeed to foster the efficacy of the military in securing the country and its borders. The enforcement of discipline within its rank and file is a vital component of that objective, but is certainly not the sole function thereof. Be that as it may, the main bone of contention as far as the jurisdiction of the General Court-Martial is concerned appears to be the status of that military court in the national judicial system. Black's Law Dictionary defines a competent court, which is interchangeably referred to as a court of competent jurisdiction, as I quote, a court that has power and authority to do a particular act, one recognized by law as possessing the right to adjudicate a controversy, close quote. In the matter before the court presently, the juridical competence of courts-martial can be deduced from the definition of a court in Article 257(1)(d) of the Constitution as juxtaposed against Articles 123(b), 137(5), and 257(2)(a)(1) of the Constitution. I find fortitude for this view in the case of Attorney General versus Joseph Tumshabe, where this court adjourned the General Court-Martial to be a subordinate court. I therefore abide the position in the lead judgment that the General Court-Martial is a subordinate court of judicature within the confines of Article 129(1)(d) of the Constitution. However, the respondent extends his displeasure to the legislature, faulting it for supposedly exceeding its legislative powers when it created the General Court-Martial under the UPDF Act and conferred it with criminal jurisdiction over non-military persons and civil offences. Parliament has a broad legislative mandate under Article 79(1) of the 1 and 3 of the Constitution to enact laws in the interest of national peace, order, and good governance. Article 210(a) and (b) further empowers Parliament to enact laws that govern the UPDF's organs and structures, as well as its discipline. Having found that the General Court-Martial is indeed a subordinate court of judicature, it follows that its establishment under the UPDF Act and the delineation of its jurisdiction therein was well within the remit of Parliament. However, the scope of that jurisdiction is a matter of contention before this court. I find that the term service offence in Section 1 of the UPDF Act would encompass the offences created under Part 6 of the UPDF Act in relation to the persons delineated under Section 1171A to F of that Act, as well as offences under any other act that are committed by the same category of persons. Hence, the scope of service offences in question restricts the inclusion of civil offences to those cases where the civil offences are committed by persons that are in active military service as delineated under section 1171A to F of the Act and on field operations. Persons that are not in active military service but only became subject to military law by dint of subsection 1171G and H of the Act would not be tried for service offences in the military courts. I now turn to the contentious question of the jurisdictional scope of the General Court-Martial over civil offences. I do acknowledge the position taken in Attorney General versus Joseph Tumushabe that there is no provision of the Constitution that restricts Parliament from vesting a subordinate court with jurisdiction that is also within the purview of the High Court. For present purposes, however, I take the view that this lacuna should be interrogated with regard to the special character of courts martial and existing international safeguards in respect of military courts. Principle 8 of the Draft Principles of Military Tribunals considers crimes committed in the course of field operations to be sufficient justification for the trial of civil offences by military courts. Indeed, Section 198(2) of the UPDF Act does recognize the function of field courts martial in presiding over offences committed in the course of field operations, I quote, where it is impracticable for the offender to be tried by a unit disciplinary committee or a division court martial, close quotes. This position is reiterated in Section 177 of the Act, albeit with additional emphasis on a civil offence translating into a service offence, whether committed within or outside Uganda. I am alive to the character of courts martial as special courts that are set up to address a specific area of the law, having a more limited jurisdiction than the courts of general jurisdiction, being faster and often not bound to follow the same procedural imperatives, and field court martials are particularly characterized by quick processes that are not unduly bogged down by the procedural imperatives that obtain in general jurisdiction civil courts, or indeed other courts martial, given the peculiar conditions within which they operate. Indeed, the Constitution recognizes the peculiarity of field court martial when in Article 137(5), it exempts their processes from constitutional references. In those circumstances, closing such field courts martial with jurisdiction over capital offences that attract a potential death sentence might appear gravely ill-advised, but for the following two critical conditions. First, to restrict field courts martials to non-capital civil offences would be to leave capital offences that are committed in those sometimes fluid situations and catered for and unaddressed. This indisputably would be inimical to the administration of criminal justice and an affront to the rule of law, which subjects all persons to the law. Secondly, Principle 17 of the Draft Principles on Military Tribunals is emphatic on the right of appeal from courts martial, which by extension field courts martial. Accordingly, the right of appeal from the decision of a field court martial does provide a vital safeguard to the exigencies of their judicial processes. Its relegation to creation by subsidiary legislation is a misnomer that ought to be revisited. In the event, I would abide the proposition in Principle 8 of the Draft Principles on Military Tribunals that the circumstances under which field courts martial operate do provide sufficient justification for their jurisdiction to try civil offences, including capital offences. Having so held, and considering that the General Court Martial sits in appeal over decisions of field courts martial, I would refrain from excluding civil capital offences from its jurisdiction. I now turn to the constitutionality of Section 1171G and H of the UPDF Act. The controversy as to the constitutionality of those statutory provisions has arisen in numerous cases with varying results. It now falls to this court, under the present appeal, to pronounce itself with finality on the matter. The fundamental question is whether the parameters that are encapsulated in Section 117, 1G and H amount to exceptional circumstances that would justify the trial of civilians in military courts. The law is a major component of public policy and would thus be vital public policy consideration for the justification of the trial of civilians in military courts. Indeed, I am alive to the duty placed upon Ugandan citizens under Objective 29 and Article 3.4 of the Constitution to uphold and defend the Constitution and the law. This perhaps explains why criminal law considers a person that aids or abets the commission of a crime or has a common intention with others in the commission of a crime is criminally culpable. Reading Section 1171G of the UPDF Act, together with Section 191C of the Penal Code Act, would suggest that a person that aids or abets a serving or active military person in the commission of the service offences delineated in Part 6 of the Act would be deemed to have taken part in committing the offence, be guilty of the offence if proved, and may be charged with actually committing it. In practical terms, Ayume Francis in Criminal Procedure and Law in Uganda posits that a person who aids and abets another in the commission of a crime may be joined in one charge sheet and tried together with those who actually commit the crime, but the particulars of the offence must clearly indicate the role of the aider and abetter. I take the view, therefore, that criminal culpability by way of aiding and abetting the commission of a service offence is sufficient justification for the subjection of a civilian to military law. I respectfully do not abide the view that such trials should not axiomatically ensue in the civilian courts. In my view, the fact that the principal offender is a person in active military service and charged with a purely service offence warrants the recourse to military courts as opposed to civil courts for the trial of both the principal offenders and their accomplices. Furthermore, the intricate nature of service offences encapsulated in Part 6 of the UPDF Act would be better suited for trial before military courts rather than civil courts. I would, however, abide the exemption posited in Oxford Dictionary of Law that, and I quote, when a member of the armed forces is charged with conduct committed in that is an offence under both service law and the ordinary criminal law, the trial must, in certain serious cases, e.g. treason, murder, manslaughter, and rape, be held by the ordinary criminal courts and is in fact usually held by them in other cases. Close quotes. I would construe this position to draw a distinction between the pure commission by a military person of a service offence on the one hand and a service offence that is also available as a civil offence. In addition, though seemingly restricted to capital offences, I would extend it to non-capital offences that accrue as both service offences and civil offences. In my view, therefore, the general rule ought to be that military service offences are only triable in military courts and civil offences are only triable in civil courts, save for two exceptions: the trial by field courts-martial of military persons that commit civil offences during field operations, and the trial of service offences by civil courts, where such offences do also exist on the ordinary criminal law statute books. I would therefore uphold the majority in the Constitutional Court that civilians that aid and abet military persons in the commission of a service offence do by their actions subject themselves to military law under Section 117(1)G of the Act. Section 1171H, on the other hand, subjects to military law any person found in unlawful possession of arms, ammunition, equipment, ordinarily being the monopoly of the defense forces or other classified stores. I find no definition in the Act as would guide a reasonable member of the public as to what type of military equipment is the monopoly of the UPDF, let alone what would amount to classified stores, so as to avoid the prohibited conduct. Article 2812 of the Constitution considers a criminal offence that is not adequately defined to undermine the right to a fair trial and thus prohibits convictions arising from vague and ambiguous criminal offences. The need for a precise definition of an offence is associated with the principle of legality that translates into the constitutional principle of void for vagueness. The void for vagueness doctrine essentially requires that a penal statute define the criminal offence with sufficient definiteness that ordinary people can understand what conduct is prohibited and in a manner that does not encourage arbitrary and discriminatory enforcement. provisions that have not been defined with sufficient conciseness have invariably been adjudged to be void on account of their vagueness. On that premise, therefore, I am unable to endorse the constitutionality of Section 117(1)H of the Constitution. In the result, I find that service offences as defined in Section 1, as well as the provisions of Section 177 of the UPDF Act, are not at cross purposes with either the legislative mandate of Parliament or the objective of the UPDF under Article 210A of the Constitution. Nor in any case are they inconsistent with Articles 28(1) and 44C of the Constitution. I do additionally find that the provisions of Section 117(1)G of the UPDF Act do constitute exceptional circumstances under which the subjection of civilian offenders to military courts would be justified. To that extent, that statutory provision is not inconsistent with the Constitution. I, however, find Section 117(1)H of the Act to be void for vagueness and therefore inconsistent with Article 28(12) of the Constitution. I would accordingly resolve ground 1 of the appeal in the affirmative, but respectfully find no merit in either ground 4 of the appeal or the cross appeal. I now turn to grounds 2 and 3 of the appeal. The right to a fair trial is anchored in the principle of judicial independence, which in the Ugandan Constitution is articulated in Article 128. In the same vein, Principle 13 of the Draft Principles of Military Tribunals proposes, I quote, "The organization and operation of military courts should fully ensure the right of everyone to a competent, independent, and impartial tribunal at every stage of legal proceedings. The persons selected to perform the functions of judges in military courts must display integrity and competence and show proof of the necessary legal training and qualifications, and military judges should have a status guaranteeing their independence and impartiality, in particular vis-a-vis the military hierarchy." Close quote. The UN Human Rights Committee additionally enjoins states to take all necessary measures to ensure that such trials take place under conditions which genuinely afford the full guarantees as stipulated in Article 14. The African Commission of Human and People's Rights has similarly adopted the stance that military tribunals must be subject to the same requirements of fairness, openness, and justice, independence, and due process as any other process. Thus, in the Constitutional Rights Project versus Nigeria, it decided that a tribunal comprised of one judge and members of the armed forces could not be considered impartial because regardless of the character of the individual members of such tribunals, its composition alone creates the appearance, if not of impartiality and bias. Close quotes. The General Court-Martial of Uganda was established under Section 195 of the UPDF Act. It is composed of 7 members, all of whom are appointed by the High Command for a period of 1 year, subject to reappointment by the same appointing authority. Its membership is solely comprised of military persons, with no provision whatsoever for their professional qualifications, although at any one time the actual members of the General Court-Martial could very well possess the requisite qualifications, its de jure composition is purely restricted to qualification on the basis of military service. In Inkawa versus Turkey, the European Court of Human Rights, the European Court on Human Rights highlighted the specific factors that would be taken into account in determining the impartiality and independence of military judges. The court astutely identified the crux of the matter as the confidence which courts in a democratic society must inspire in the public, and above all, as far as criminal proceedings are concerned, in the accused. It further deduced the parameters that will support the independence and impartiality of military judges, to include the same professional training as civilian judges and the enjoyment of constitutional safeguards identical to those applicable to civilian judges. It additionally expresses concern about military judges being servicemen who still belong to the army, which in turn takes its orders from the executive. And they remain subject to military discipline, and the appointment of these officers is made by army
structures for a short renewable term. That decision is most persuasive on the standard of independence and impartiality expected of military judges or military courts. In any event, the concerns expressed in it are re-echoed in Principle 13 of the Draft Principles on Military Tribunals. Paragraph 7 of that draft principle emphasizes equivalence in professional qualifications, ethical standards, and constitutional safeguards between judges in civilian courts and their counterparts in military courts as a safeguard for their independence and impartiality. In the matter before us, the respondent, having pointed to the impugned Section 195 as the legal basis for his misgivings with his trial before the General Court-Martial, the evidential burden shifted to the appellant to factually demonstrate the independence and impartiality of that court. Regrettably, such evidence was not forthcoming. I do not accept the appellant's proposition that military courts in Uganda are impartial and independent simply because Article 221 of the Constitution enjoins the UPDF to observe and respect human rights in the performance of its functions. In my view, that constitutional imperative is simply a directional standard for courts martial rather than a factual situation that pertains to them. Consequently, in complete agreement with the lead judgment, I find that the Constitution of the General Court-Martial does compromise its independence and impartiality as a subordinate court of unlimited jurisdiction, and is to that extent inconsistent with Article 28(1) and 44(c) of the Constitution. In the result, I would resolve ground 2 of this appeal in the negative. On the other hand, under ground 3 of the appeal, the respondent's arraignment before the General Court-Martial is specifically challenged on account of the omission in the charge sheet to indicate his role in aiding and abetting the commission of a service offense as contemplated under Section 117(1)(g) of the UPDF Act. As was earlier observed here, a person that aids or abets another in the commission of an offense is deemed to have taken part in the commission of the offense and, if proved, would be guilty of that offense. In the instant case, an incomplete charge sheet was annexed to the affidavit in support of the petition as Annexure A. It reveals that A1 to A8, with whom the respondent was arraigned, were at the time in active military service and therefore automatically subject to military law. The respondent, on the other hand, is depicted as a civilian, a member of the 10th Parliament of the Republic of Uganda, representing the Kawa Division in Kampala District, and designated as a person subject to military law by virtue of Section 119(1)(g), 117(1)(g) of the UPDF Act. Under count 1 of the charge sheet, the statement of offense is stated as offenses relating to security, contrary to Sections 131F of the UPDF Act, while the particulars of offense indicates that the respondent, together with 22 other named persons and others still at large, between the months of February and June 2016, in diverse places in Wakiso, Kampala, and Buries districts, with intent to prejudice the security of the defense forces, contrived a plot to overthrow the government of Uganda by force of arms. Close quotes. Although the charge sheet referred to in Section 117, I'll say that again. Although the charge sheet referred to Section 117(1)(g) of the UPDF Act under the description of the respondent, it did not spell out his role in the commission of the alleged service offense. This would indeed amount to a defect. However, not every defect in a charge sheet would make it bad in law and render the ensuing proceedings a nullity. The test to be applied is what the effect of the defect is and whether, if proceedings are concluded, it has occasioned a miscarriage of justice. In this case, no attempt was made to demonstrate any such miscarriage of justice. On the contrary, insofar as the charge sheet highlights the statutory provision that brings the respondent under military law, which is clear on the issue of aiding and abetting the commission of a service offense, the respondent would have been on notice of the nature of offense he was arraigned for. Furthermore, the charge sheet spells out the principal offenders by highlighting their status as persons in active military service. Moreover, borrowing from the civilian courts, under Section 132 of the Magistrates' Courts Act, a court that is faced with a defective charge has a wide discretion to amend it at any stage of a trial. As a similarly subordinate court, that option of amendment of the charge would have been available to the General Court-Martial to clarify the specific role played by the respondent in the alleged offense, as well as demarcate who of the persons he was arraigned principal offenders. Consequently, given the procedural reliefs available to him, I do not find the defects in the charge sheet in this case to constitute sufficient reason to declare the respondent's arraignment before the General Court-Martial a violation of the right to a fair trial. However, given the then de jure composition of the General Court-Martial under Section 195 of the UPDF Act, the respondent's arraignment before that military court cannot have been in accordance with the right to a fair trial before an independent, impartial, and fair court, as envisaged in Article 28(1) of the Constitution. I would accordingly resolve ground 3 of the appeal in the negative. This brings me to what would be appropriate remedies in the circumstances of this case, and whether or not they should apply retroactively. Black's Law Dictionary distinguishes true retroactivity from quasi-retroactivity, the former consisting of the application of a new rule to matters that were completed before the rule came into force, and the latter entailing the restriction of a new legal rule to matters pending completion. In Griffith versus Kentucky, the U.S. Supreme Court reiterated its view in United States versus Johnson on the need to apply a new constitutional rule to all criminal cases pending determination in order to uphold basic norms of constitutional adjudication. That case was cited with approval by the Constitutional Court in Mabea versus Attorney General, and I still consider it to be good law. I would thus equally cite with approval the observation in Duke Mabea versus Attorney General that a new constitutional rule in the realm of criminal procedure be applied quasi-retroactively or restricted to cases pending final disposal to avert the dire effect on the rule of law and the administration of justice of full retroactivity. Griffith versus Kentucky additionally posits that unlike the legislature, it is not the function of the judiciary to formulate laws on a broad basis, its role being limited to the declaration of a new rule directly arising from adjudication. This is similarly acknowledged by the Canadian Supreme Court in the case of Spector versus Canada. That case was relied upon in Fish-Eric in the article Choosing Constitutional Remedies by Fish-Erickson. The choice of appropriate remedy between severance and reading in, where a statutory provision violates the Constitution, hinges on whether the nature of the constitutional inconsistency entails something improperly included or excluded from the statute. In the matter before us presently, Section 195 excludes such professional competencies in the membership of the General Court-Martial as would mitigate connotations of partiality and non-independence. As such, reading those omissions into that provision might have been the more appropriate remedy, but for the fact that the deference to the competence of persons with a military background was at the time informed by the scarcity of legal professionals in the military, as well as the complexities of securing legal professionals for field courts-martials. This is borne out by the parliamentary debate in respect of the then Uganda People's Defense Forces Bill, as reported in the Hansard of that time. So that reading into Section 195 of the UPDF Act, the constitutional safeguards and membership as the court deems appropriate would be tantamount to the usurpation of Parliament's legislative function by judicial overreach. However, the same SAPTA case provides the legislature a chance to craft its own solution. Provision for legislative reform therein would, in my view, address the shortfalls of the previous legislative process and provide an opportunity for the review of the military justice law in Uganda, as has been done in other jurisdictions. This would align it with the independence and impartiality safeguards envisaged in the right to a fair trial under the Constitution. It will suffice to observe here that unlike judiciary-driven reforms that ought to be restricted to matters that were in contention between the parties, legislative reform may holistically address matters that were not necessarily in issue before this court. It might similarly accrue to the right to a fair trial in courts-martials. This would forestall avoidable litigation in respect of related matters and abide the notion of judicial economy. Disposition position. The upshot of my judgment is that this appeal partially succeeds while the cross appeal fails. I do abide declarations 1, 2, 3, and 6, orders 3 and 7, as well as the advisory orders D, E, and H as stated in the lead judgment. In the result, I would set aside the judgment and orders of the Constitutional Court and substitute them with the following declarations. 1. The General Court-Martial is a subordinate court of competent jurisdiction within the confines of Articles 129(1)(d) and 257(1)(d) of the Constitution, but its de jure membership under Section 195
To grant, in this case, my perspective on these questions is as follows. The first question being on regarding the limits under the 1995 Constitution on the jurisdiction of the military courts. I find that the military courts are established as military organs of the UPDF under Article 2010A, and that take interest in the best practices set out in the respective judgments of the Honorable Chief Justice and Bamugemereire, which represent the best reforms to improve the military court system. These are found on pages 19 to 20 of my judgment. In conclusion, and for the reasons given in my judgment, which you get, I would disallow the grounds of appeal and allow the sole ground of cross appeal. I would make I'll take on the declarations numbers 4, 5, 6, 7, and 9, and orders 1, 2, 3, 4, 5, and 7 contained in the judgment of the Honorable the Chief Justice, since they are consistent with the findings in my judgment. I would also commend the Honorable Chief Justice's advisory orders to the attention of the learned Attorney General. I would then make the following separate declarations arising from the findings in this judgment, in addition to the ones I pointed out above contained in the judgment of the Honorable Chief Justice. Number 1, General Court-Martial is not a subordinate court within the meaning of Article 129(1)(d) of the 1995 Constitution. General Court-Martial and other military courts are disciplinary organs of the UPDF established under Article 210, whose jurisdiction is limited by Article 210B to handling matters related to discipline and removal of members of UPDF, including former and assimilated members of the UPDF, as stipulated under Section 1191 A to F of the Act. Number 3, the jurisdiction of the General Court-Martial and other military courts is under 210B, limited to hearing matters involving disciplinary offences under Part 6 of the UPDF Act, committed by members
with jurisdiction to handle offences specified in the Act, only for penal and disciplinary purposes. The General Court-Martial was therefore established as a specialized court of the military forces. On the other hand, the Constitution also establishes courts of judicature empowered to exercise judicial power with various jurisdictions under Article 129 of the Constitution, which states that the judicial power of Uganda shall be exercised by the courts of judicature, which shall consist of A, the Supreme Court of Uganda, B, the Court of Appeal of Uganda, C, the High Court of Uganda, and
and such subordinate courts as Parliament may by law establish, including Kadis courts for marriage, divorce, inheritance of property and guardianship, as may be prescribed by Parliament. 2. The Supreme Court, the Court of Appeal, and the High Court shall be superior courts of Britain, and shall each have all powers of such court. And 3. Subject to the provisions of this Constitution, Parliament may make provisions for jurisdiction and procedure of the courts. Both the courts martial and the courts of judicature therefore have their origins from the Constitution, save that while the Constitution directly sets up the courts of judicature under Article 129, the courts martial are set up by an act of Parliament as mandated under Article 129(1)(d) and 210 of the Constitution. The criteria for appointment of members who sit on the General Court Martial set out under Section 195, the revised version of the Laws of Uganda 2023 of the UPDF Act, is that they should essentially be army officers, with the chairperson not being below the rank of a Lieutenant General. Save for the chairperson of the Court Martial Appeal Court, who is required to be an advocate, qualified to be appointed as a judge of the High Court. Legal qualification is not a basis for appointment on the General Court Martial and the other military courts set up under the UPDF Act. In contrast, under Article 143 of the Constitution of Uganda, persons qualified for appointment as judicial officers in the courts of judicature as established under Article 129 of the Constitution of Uganda must have legal qualifications.